Purely voluntary arbitration might work for commercial disputes, you might say. But what about the bad guys, the thief, the rapist, the killer, none of which live on rape land? Once again, let's say A is being accused of stealing from B. If A and B both belong to the same court, there's no problem. If A and B belong to different courts, it is likely that the case would be tried at A's court because A is the one lodging the complaint and thus is calling upon his judicial services, though the court system of B would uphold the verdict, just as the U.S. courts uphold the decisions of Canadian courts. It must be remembered that even if B is accused of theft, no one can force him to be present at his trial, because this would be a violation of the non-aggression axiom. A voluntary subpoena would have to be issued to tell B that he, B for boy, is being accused and should be present to defend himself, which would probably help his case. But he would be under no obligation to do so. If B does not appear, he would likely be tried in absentia, and whatever decision the court handed down would be upheld. If B is found guilty, either the court's police service or A's would come and seize him to exact whatever punishment is decided upon by the court, which would likely include being thrown into one of the fine jails that have already been established previously. Well, these courts certainly aren't fallible. What happens if they get it wrong and a convicted criminal wants to appeal the court's decision? Well, good businesses would recognize this. That they are not 100% efficient and they are not 100% correct all the time. And thus, incorporated into every private court's services would likely be an appeals procedure. Now, perhaps, written into the contract of the judicial service company is the stipulation that the verdict of the appeals court procedure will forever be upheld, or each case can possibly be appealed a certain number of times, or each person can appeal until he runs out of money, or whatever. Whatever would be decided upon the free market. But I suspect that to cut down on the cost of appeals ad infinitum, there would be an agreed upon cutoff point between A and B, stipulating that once such and such a decision is reached, it would be binding and there would be no further appeal. I do not know specifically what would happen, but neither do I know how many friolators McDonald's needs. These kinds of decisions must be made by all voluntary actors involved, not just by me. If I had all the answers as to everything that would happen in an anarcho-capitalist society, I would merely be a bureaucrat or a king preaching for his own demise. The beauty of anarchy is its freedom, its fairness, and its variation. Okay, you might say. So we've got these private cops, and maybe I'll even agree that we've got these private courts, but just how in the hell could a legal system possibly develop? You listed the problem yourself. Would there be individual rules or universal rules? Huh, you douchebag? Answer me that. I would respond, okay, calm down. Second of all, let me walk you through how I think the problem of legal services would be addressed. Laws are necessary for private courts. Most laws are unnecessary for most people because all the key laws, the really important ones, are mostly ingrained into us. Do not murder people like you. Do not steal from your neighbor. Do not aggress against others. And in general, do not do unto others and in general, do unto others as you would have them do unto you. Most people already, in a sense, know and follow these. Each of these springs from our two original concepts, the sovereignty of the individual and the non-aggression axiom. Thus, I would say these two precepts would be necessary for everyone to follow in an anarcho-capitalist society, but other principles of law would have to be established. Other principles of law would have to be established. This would probably be the definition of property rights, set up the rules of evidence, and establish punishment procedures. There would possibly be a handful of general laws which everyone could possibly carry around in their back pocket and know and understand, and the rest would be derivation by local judges applying their knowledge of justice as best they can. There's no reason for law to be as complicated as it is now. It can only bring about confusion and be more prone to injustices. Private law has existed in many forms throughout history, such as medieval Iceland, Celtic Ireland, the American West, mercantile law, and sea laws. Finally, even Anglo-Saxon common law was developed over centuries by competing judges who applied time-honored principles rather than being subject to the shifting and arbitrary decrees by the state. The fact that each of these systems worked so incredibly well for so long, for such long periods of time, Celtic Ireland, for instance, lasted about 1,000 years. English common law has existed since the 12th century. The Icelandic system, roughly 200 years, is further evidence that such systems can and do work. Even further evidence toward the greatness of private courts and separate laws is the fact that private courts can in no way make laws as they can now. This is because judges can only make decisions when private individuals bring the cases to them. Each judge's decision would apply specifically to a particular case, and though precedents could be established, they would not be legally binding as they are now. Thus, an error made early in jurisprudence would not have the significant and devastating effect it has now. This view, that law is to be found within general principles, is considerably different than the modern idea that law is something which is to be enacted. Since judgmentship is in a totally private society, would be a skill, something which must be earned through a good reputation, and acknowledged expertise, fairness, and the ability to properly apply common legal principles. It is obviously that the judges that would judge would be chosen by the people. That is to say that good, impartial, and objective judges, assuming these are the qualities people want in judges in the long run, are the ones who will be hired to perform the task of applying the law. As Bruno Leoni made perfectly clear, it is no different to hire a judge than it is a physicist or a doctor. The emergence of good professional people in any society based on widespread consent on parts of the clients, colleagues, and the public at large. Of course, people can be wrong about the true value chosen as being worthy, but these difficulties in choice are inescapable in any kind of choice. This fact also suggests the possibility of professional jurors who would be selected to make legal decisions. 12 smart people are probably more likely to be more right than one smart person is. Anybody could recognize this, and certainly people whose business it is to create good judicial services could recognize this, and therefore the establishment of trial by jury is not only not out of the picture, but could very well be a key function of many judicial services. Okay, so even if private police, legal systems, and courts could work, how are you possibly going to defend these systems? Who will protect us against the Chinese? Or if you're kicking it old school, the Ruskies? One surefire way I'm not going to advocate doing it is through a coercive government. As Rothbard reminds us, government is no more necessary, you can read this along with me, is no more necessary for providing vital protection service than it is necessary for providing anything else. Its compulsory monopoly over the weapons of coercion has led it, over the centuries, to infinitely more butcheries and infinitely greater tyranny and oppression than any decentralized private agencies could possibly have done. If we look at the black record of mass murder, exploitation, and tyranny levied on society by governments over the ages, we need not be loath to abandon the levy-ban state and try freedom. In fact, just a little bit of numbers to take home with you are these interesting statistics. According to political scientist R.J. Rummel, about 35 million people died in all the wars of the 20th century. During that same time, it is estimated that anywhere from 170,000 to 170 million to 260 million people died due to their government. If governments are meant to protect life, liberty, and property, apparently war is about 5 times better at it. But the question to ask, who will protect us against the Ruskies, assumes several dubious things. First of all, it assumes that they are out to get us. There's precious little biological, psychological, or anthropological evidence to suggest that the majority of humanity is hell-bent on destroying other people. In fact, it is most often these very sentiments can be traced back to the nationalism which breeds contempt and xenophobia, among other things. Secondly, it assumes that the Ruskies would maintain their desire to destroy America even after America has already been done away with. Keep in mind, it's right there in the title. Anarcho-Capitalism. No state, no United States. The belief that any state would still be an anarchic society